Well, good evening, everyone. Welcome to our CLE for tonight, and thank you for joining. I'm Richard Benson, and along with my colleague Eric Wesson, and on behalf of the board of the Chicago Lawyers Chapter of the Federalist Society for Chicago, I'd like to welcome you to tonight's discussion. We have submitted tonight's event for MCLE approval for the state of Illinois and also for diversity and inclusion credit. Tonight's event is Balancing Religious Liberties in a Pluralistic Society, the Perilous State of Employment Division versus Smith. America finds itself at quite a crossroads in reference to our interpretation of how religious liberty intersects with other interests in our society. Over little more than a generation, according to the Pew Charitable Trust, our society has shifted remarkably from being a society of mostly regularly practicing Christians of a handful of denominations to a diverse pluralistic society where the fastest growing single segment are those who do not affiliate with any religion at all. Meanwhile, our society's general opinions have shifted on several topics that disagree on how people might choose to live their lives according to their creeds. Add to this situation a global pandemic, and religious institutions may feel that they are being treated differently than organizations that they would see as their factual peer. Meanwhile, over the last couple Supreme Court terms, the court has heard several cases that affect the free exercise clause, the ministerial exception, and the anti-establishment clauses of the First Amendment. Can any discernible trend be found? Moreover, with the granting of cert in Fulton versus City of Philadelphia, the adoption case that is pending next session, there's a very strong chance the Supreme Court could reformulate the existing precedent of employment division versus Smith. All of this leads us to tonight's important question. How should our society structure religious liberty in our pluralistic society, especially when it meets a situation of disagreement or unpopularity amidst a bevy of competing interests? We are very appreciative that 3 subject matter experts agreed to participate in today's discussion. The format of tonight is a moderator and 2 panelists. I'm going to go ahead and introduce our moderator and let my colleague Eric Wesson introduce our 2 panelists, and then we'll turn the floor over to the experts. So final word about logistics tonight. Our presenters will discuss among themselves until about somewhere 6:50, 7 o'clock Central, when the discussion feels like it has matured. When we get to that portion of the evening, please utilize the Q&A feature below. Feel free to ask questions even during the event so our presenters can think about it and formulate their responses a little bit early. Without further ado, let's get to the experts. I'm pleased to introduce tonight's moderator, Professor Daniel Conkle, the McKinney Professor of Law at Indiana University Maurer School of Law in Bloomington. He's been a member of the faculty there since 1983. Professor Conkle teaches constitutional law, the First Amendment, and law and religion. His long career of research addresses the constitutional law in theory, religious liberty, and the role of religion in American law, politics, and public life. His most recent book is Religion, Law, and the Constitution. Professor Conkle also held the record for the highest student GPA earned at the Ohio State College of Law and has had a long career teaching and is beloved by the Maurer Law community. He'll be moderating tonight's panel. Now I'll pass it over to Eric to introduce our 2 panelists.
Thanks, Richard. Professor Stephanie Barclay is a First Amendment scholar currently teaching at Notre Dame Law School. She researches and writes about the role our different democratic institutions play in protecting minority rights, particularly at the intersection of free speech and religious exercise issues. Professor Barclay's academic writing has been published in many journals and law reviews, as well as popular news outlets like the New York Times. Professor Vincent Philip Munoz is the Tocqueville Associate Professor of Religion and Public Life in the Department of Political Science at the University of Notre Dame, where he founded the minor in Constitutional Studies and directs the Tocqueville Program for Inquiry into Religion and Public Life. Munoz writes and teaches across the fields of constitutional law, American politics, and political philosophy with a focus on religious liberty in the American founding, including his first and notable book, God and the Founders, Madison, Washington, and Jefferson. Thank you all for coming to participate today, and now I will hand over the reins to Professor Conkle.
Very good. Thank you very much. It's a real pleasure to be participating in this event with all of you, including Professor Barclay and Professor Munoz. And it's a special pleasure to have been invited to participate by one of my favorite former students, Richard Benson. So welcome to all of you who are here tonight. First Amendment has 2 religion-related provisions. As Richard mentioned, you have an anti-establishment provision, and more to the point for tonight, There is a free exercise provision protecting the free exercise of religion. And in essence, I want to just very briefly give a thumbnail sketch of the contemporary law and a little bit of background about the state of free exercise law. Free exercise challenges, broadly framed, are of two different sorts. One is a claim or an allegation that the government has discriminated against religion or against religious practices or against religious institutions. And that's one prong or one type of a free exercise challenge. The other, and the one at issue in cases like Employment Division versus Smith, is a claim that the free exercise clause requires special treatment for religion, special accommodation for religion in the form of a constitutionally required exemption from a law that otherwise would be applicable without regard to any claim that there has been actual discrimination against religion. The first prong or the first type of free exercise challenge, the prohibition on discrimination against religion in the abstract, is not controversial. It's a consensus point that the government cannot discriminate against religion. Where it becomes contested is in particular applications or in particular aspects of its meaning. At a minimum, the government cannot target religious practices or religious institutions for special penalties precisely because the practice or the institution is in fact religious, as the Supreme Court held in a 1993 case, Lukumi, Church of the Lukumi Babluai versus City of Hialeah, Florida, ruling that the city had in fact targeted the Santeria religion for special discriminatory treatment by banning animal sacrifice within that community. More controversially, and even this term, the Supreme Court has extended the anti-religious discrimination prohibition to denials of funding for religious institutions, including in the recently decided case of Espinoza versus Montana, that the state of Montana could not exclude religious schools from an otherwise applicable government promoted, government sponsored scholarship program, that to deny that funding amounted to discrimination based on religious status, forbidden by the Free Exercise Clause, even though in an earlier era, that prohibition on funding might have been thought to be required by the Establishment Clause of the First Amendment. In so ruling, the Supreme Court ruled that a state constitutional provision, so-called mini Blaine provision, could not be applied in the manner that the state of Montana had attempted to do so, because it would entail this forbidden discrimination on the basis of religious status. Yet another application of the anti-religious discrimination principle was in the highly publicized case of Masterpiece Cake Shop, where the Supreme Court managed to avoid broader issues by ruling that the Colorado Civil Rights Commission had exhibited anti-religious animus against the Christian baker in that case, who sought an exemption from an otherwise applicable public accommodations law that was interpreted by the Civil Rights Commission to require him to bake cakes, if he's going to bake wedding cakes, to do so equally for same-sex weddings as for opposite-sex weddings. So there's some debates about the application of the anti-religious discrimination principle, but the principle itself is generally accepted by consensus. More controversial at a deeper level is the issue of religious exemptions. And in essence, for about 30 years, from 1963 until 1990, the Supreme Court ruled that even a neutral and generally applicable law would violate the Free Exercise Clause if it were applied in such a way as to substantially burden a religious practice, unless the government could justify that intrusion on the religious practice by showing that it had a compelling interest that required that the law extend even to the religious practice. Two notable cases, Sherbert versus Werner in 1963, Wisconsin versus Yoder in 1972, elaborated and applied that proposition, ruling in the first case, Sherbert, that Saturday work requirements could not be extended to a Saturday Sabbatarian. And in the second case, ruling that members of Wisconsin Amish community, parents could not be required to comply with compulsory school attendance law when their religion taught them that children should stay home, basically by the time they reached high school age. That doctrine shifted radically in 1990 with the case of Employment Division versus Smith, where through an opinion by Justice Scalia, the court not only denied a free exercise exemption claim that was brought on behalf of members of the Native American Church who sought to use a hallucinogenic substance, peyote, in a sacramental religious ritual. They sought exemption from a criminal drug law. The Supreme Court denied their exemption request and, more to the point, ruled rather broadly that at least going forward, the free exercise clause, generally speaking, simply would not require religious exemptions, essentially rendering neutral and generally applicable laws immune, essentially, from free exercise challenge. Employment Division versus Smith was designed, at least in part, to clarify and simplify the law. I would suggest that it has not done that at all. Instead, we have increasing confusion in a rather convoluted doctrine. How is that so? Well, in the first place, the Supreme Court has ruled that the free exercise clause, I should say lower courts have ruled, that the free exercise clause itself, sort of as an offshoot of the anti-religious discrimination principle, sometimes requires exemptions for religious practices, even if a law does not deliberately target religion for disadvantage, if the law contains any kind of a secular exception that might be otherwise comparable to the religious practice. That issue of whether or not a law is generally applicable and therefore immune from a free exercise challenge is presented, for example, in recent cases challenging some of the coronavirus-related executive orders by governors that exempt certain commercial businesses, for example, but not religious worship. Is that a comparable situation or is it not? Is a grocery store like a religious worship service? Is a casino like a religious worship service? So you have that prong of free exercise clause doctrine maybe still prevailing even after Smith. Secondly, as Richard mentioned at the outset, the free exercise clause itself, coupled with the establishment clause, has been interpreted to require a so-called ministerial exception from employment discrimination laws, an exception construed most recently by the Supreme Court this term in the Our Lady of Guadalupe case to mean seemingly that parochial school teachers, at least most of them, maybe virtually all of them, cannot bring employment discrimination claims against their religious employers. Third, and perhaps most significantly in terms of the complexity of free exercise exemption doctrine, we have exemption law that comes not directly from the free exercise clause, but instead from a federal statute, the Religious Freedom Restoration Act of 1993, another federal statute, the Religious Land Use and Institutionalized Persons Act of 2000, from state law, so-called mini-RFRAs, from state constitutional law, all of which essentially says that as to federal laws, the federal RFRA requires the pre-Smith approach as a matter of statute, has been used, for example, in the Hobby Lobby case of a few years ago, dealing with the Affordable Care Act's so-called contraceptive mandate. You have roughly 30 states as a matter of state law, either a state law RFRA or state constitutional law, applying the pre-Smith approach. So Smith doesn't really entirely control the law of free exercise at all, and it has this general applicability complication that makes it unclear exactly where that law in fact extends. As Richard mentioned, and I'll wrap up my introductory remarks here, we have pending before the Supreme Court in the Fulton case, among other things, the question of whether or not the Supreme Court should revisit Employment Division versus Smith and potentially overrule it and replace it either with pre-Smith doctrine or perhaps with something else. And we will see what happens when that case is argued next term and presumably decided sometime probably next spring. Okay, with that, I will pass the baton to Professor Barclay for her initial presentation.
Thanks, Dan. That's a great overview. Thank you to the organizers of this event. It's a great opportunity to get to be with you virtually if we can't be together in person and to talk about these important issues. As I think Richard really honed in on, the important question is, how should a pluralistic society with people of all different types of religious beliefs, or none at all, how should such a society organize itself? And as Dan pointed out, most people agree, certainly we shouldn't have a society where the government is able to single out religious groups for bad treatment just because of their religious beliefs. So that's not controversial. But where the rubber really meets the road in a lot of these disputes is, what do we do about situations where religious people are still facing significant burdens from government laws and policies? How should we handle those situations? The principle that I would suggest is that it is desirable to have a society where the government tries to avoid unnecessary interference with religious exercise where possible. Sometimes it will be necessary to avoid significant types of harm that are directly resulting from some sorts of religious practices. But I think often it's possible for us to find ways to live in a live and let live society where religious people can live their beliefs and government can still accomplish its goals. And that often looks like offering what we call religious exemptions from laws. I'm going to provide just 3 arguments in favor of why I think this approach makes sense. The first one is a doctrinal argument. Sometimes people argue that religious exemptions are asking for special treatment or a get out of the law free card, that there's something unique about this in the religious context. But in fact, one thing that I've argued before in a Boston College Law Review is that religious exemptions are simply another version of what we do all the time in constitutional law, and that is offering as applied challenges to different types of laws. The Supreme Court has described as applied challenges as the bread and butter of constitutional adjudication, a basic building block of how we defend the Constitution while still protecting rule of law norms. What as applied challenges look like is that they will leave a law generally intact, but will say this particular application of the law butts up against higher constitutional values, and therefore that application isn't valid. That's exactly what a religious exemption does, is to say this particular application of the law to this particular religious objector or type of religious objectors isn't allowed. We allow this sort of challenge, a narrow targeted challenge to go forward all the time in the context of freedom of speech. This is one of the most important ways in which we protect freedom of speech from broad sweeping laws. And so as a doctrinal matter, if we don't allow that same sort of foundational protection to be allowed for religious exercise, then what looks like an anomaly in the law is our approach to religion, where we're giving less protection to religious sorts of First Amendment rights than we do to other rights under the First Amendment. The other doctrinal reason is because, as Professor Conkle pointed out, the current approach under Smith is itself pretty convoluted doctrinally. I think Justice Scalia in that decision was trying to avoid complications, but in fact it turns out deciding what counts as a generally applicable law is really complicated, as some of these recent COVID cases point out. Is a restaurant more like a church or a casino? How do we decide? It turns out a lot of those questions are the type of questions you actually dig into in strict scrutiny, and trying to decide it on a preliminary step without having the government marshal evidence about that turns out to be pretty unworkable in a lot of instances. The second reason I would argue in favor of this approach of providing religious exemptions and avoiding unnecessary religious interference with religious exercise is a historical one. Our country, during the founding period, had some religious objectors that in the beginning we didn't treat very well. Some of these groups included Quakers who objected to performing oaths. Other religious groups did as well. And the Quakers also had an objection to military service. And some jurisdictions in the early republic of our country tried to force the Quakers to serve in the military anyway. And if they wouldn't, they would throw them in jail or worse. And what we learned from this historical practice is that we weren't actually accomplishing our goals of having a better military. We were just sending a lot of Quakers to jail or punishing them in even more severe ways. And so we were not actually advancing the government's interests while simultaneously increasing human suffering. And so what a lot of jurisdictions started doing is offering religious exemptions and saying that this is a value that matters to our country. The idea that we can protect conscience for objectors that have a different view that might be unpopular and different, and we can still let the government accomplish its interests. There's a note that those laws about military conscription or saying oaths weren't discriminatory. They weren't targeting Quaker people, but they happened to have a particularly burdensome effect on those individuals precisely because their religious beliefs were less known and less popular, and so weren't likely to be reflected in our laws and in the general policies that more powerful religious groups could make sure automatically would protect them, and the sorts of laws that applied to everyone. There's a debate about whether or not providing these exemptions should only be the prerogative of the legislatures, or whether there is a constitutional norm that can be enforced by the judiciary. This is a question that I take up in a recent Notre Dame Law Review piece about the historical origins of judicial religious exemptions. And I argue that there is strong evidence supporting the idea that the judiciary, even during the founding period, often provided exemptions from different types of generally applicable laws to protect a host of individual rights, not just religious ones. My third argument is a normative one. If we think about that example of the Quakers that I was just talking about being thrown in jail and increasing human suffering, I think the opposite is what we are trying to achieve with religious exemptions, and that is to avoid needless human suffering. Religious individuals often have beliefs that others in society view as idiosyncratic. They value their ability to engage in certain activities or to abstain from engaging in certain activities much more than the average citizen would, which means that they're often not going to behave sometimes in the ways that average sorts of penalties or incentives that government offers apply to other citizens. And elsewhere in the law, there's a lot of economic literature about the fact that when people have idiosyncratic valuations about other things that are important in their lives, whether it's their house or other goods or services, usually the government has to be pretty cautious about forcing those individuals to engage in transactions, forcing them to do something that they don't want to do. And that's basically what a religious exemption framework right now, under an approach like strict scrutiny, would require, is the idea that because religious individuals have beliefs that make it more difficult for them to sometimes move forward with activities that others in society wish, then government needs to have a strong justification for forcing their hand, so to speak. And the government also needs to see if there are other ways that government can accomplish its goal without being engaged in these sorts of conflicts. And my argument is, and we can drill down on this more, there are often ways in which the government can both accomplish its goals, protect other individuals who are not religious in society, and find ways to protect religious people so that we can reduce human suffering and increase human flourishing, which I think is one of the most important objectives at stake with this type of framework. Thank you. I'll turn it over to Professor Munoz.
Thanks, Stephanie. It's always a pleasure to be with Professor Barclay, and let me welcome you publicly in this way to Notre Dame. We're absolutely thrilled to hear you, and always nice to see Professor Conkle. I said yes to be on this panel just so I could listen in and be in conversation with them and with everyone watching here. It's a pleasure to be with you all, and I'm sorry we can't be together in person. I just have two relatively brief points to make, and then we can maybe turn it over to conversation, which I always find usually the most interesting parts of these panels. So I want to start with a quote here among many commentators on the religion cases decided this year, those on the left, at least on the religion cases, have been talking about a constitutional revolution, a conservative constitutional revolution, a real right turn in the law. And I can understand why they would say that, but I don't really agree. But let me read you this quote. This is from two very distinguished law professors, Erwin Termininsky and Howard Gilman. In writing about the religion cases this term, they say, it is becoming increasingly clear that long-standing principles concerning the First Amendment religion clauses are being discarded by the conservative justices. And which they lament. I don't quite see it that way. I do see a change in the outcomes of many cases. Certainly, if we had, we're in the 80s and had the court of the 80s, or Justice O'Connor being the swing vote, many of these cases might have come down differently. But the reason why I'm hesitant to ascribe a conservative revolution to what's going on right now is the court's not really overturning any doctrines. What I take from this term's decisions was how they reflect John Roberts' jurisprudence. Very incremental. So the court does seem to be reaching what many would consider more conservative results, but not in a radical way at all or a dramatic way at all. And let me just use one case to explain this point. The Espinoza versus Montana. This is the case that Professor Conkle alluded to in his introduction. It involved, at least from those who are challenging the law, a case of religious discrimination. The state of Montana had a Blaine Amendment, and it was a little bit complicated. It's a tax exemption, and could a tax exemption be used for a scholarship program where kids would, you get the exemption and the scholarship for going to religious schools in Montana, because the Blaine Amendment said, well, you could do this for private schools, but not for religious schools. It's true that a decision for Montana could have easily been justified on many separationist precedents. The endorsement test, perhaps, but certainly the Lemon test, which says one of the prongs of the Lemon test is no aid to, no advancement of religion. And you could say, well, if this tax credit is basically subsidization of religious education, and that's aid to religion. The court came down differently. The court didn't overturn Lemon. And for someone who studies the law and the doctrines, what's remarkable to me is how these conservative justices actually aren't overturning anything. They're using their own approaches. Justice Roberts has basically a non-discrimination, at least based on religious status approach, but Lemon is still out there, not been overturned, and therefore I don't really see a revolution in the law. What I find most interesting about the case is the difference between Chief Justice Roberts and Justice Thomas. And Justice Thomas, in a concurring opinion in this Espinoza case, says, look, we're going to keep on running into problems here. Today we decide this court on free exercise grounds. We don't touch Establishment Clause precedents, but Establishment Clause precedents, he basically says, might lead to an opposite decision. Justice Thomas has been pressing the court a long time to make the law more coherent, and by overturning what are, in his opinion, bad precedents. I don't see the Roberts Court doing that, and I ascribe this to the Chief Justice himself. That's not his way of doing things. That's particular. I mean, that's interesting in and of itself, but it's also interesting when we come to case next term, Fulton versus Philadelphia, which the Smith decision is possibly up for grabs and might be overturned. And I raise this as a question for all of us to discuss, whether we think it's going to be overturned or not. I just don't think it's going to be, and I think it's not going to be overturned, even if the religious plaintiffs, even if they're victorious. I just don't see the votes to overturn the Smith decision because it's not to Chief Justice Roberts' style, and I think he'll probably be able to keep Justice Breyer with him, and Kagan and Ginsburg and Sotomayor. So I don't think there's 5 votes to overturn the Smith case. Let me make one additional point. So those were my 2 points. Maybe one additional point came to mind while Professor Barclay was speaking. There's another very interesting discussion that Smith will bring up among conservative scholars and perhaps even the more conservative or originalist justices. There are very strong originalist arguments both for keeping Smith and for overturning Smith. Michael McConnell has authored probably the most thorough and best argument for saying that the Smith decision is incompatible with the original meaning of religious exemptions. Professor Barclay's scholarship has supported that position. They would argue that religious exemptions are consistent with the original meaning, and therefore Smith should be overturned. Perhaps the most notable figure on the other side is Philip Hamburger at Columbia Law School, who's in a very strong case, at least in my opinion, that the original meaning does not mean exemptions, and therefore Smith should be retained. I'm very curious to see how these originalist justices deal with these very strong originalist arguments on each side. I really don't know how, let's say, Justice Thomas or Alito or Gorsuch or Kavanaugh will decide the case at all. I'm also curious to see if we get a version of something sort of like living originalism. And here you might see something something like the following. Whether or not religious exemptions are consistent with the original meaning of the clause, the Texas clause, the underlying purpose or the general principle animating the First Amendment was to protect robust religious expression and robust religious exercises. The evidence maybe it's not altogether clear, but therefore for us today, given changing circumstances, a decline in religion, as Professor Conkle mentioned, the nuns are the fastest growing group, religious group, even though they're non-religious themselves. To accomplish the founder's end today requires religious exemptions. That's not the type of originalist argument that I advocate. It reminds me a lot of Justice Brennan's own jurisprudence, his living constitutionalism. And that's how we got exemptions in the first place in the Sherbert case. It would be interesting to me to see if some of these originalist justices adopt a version of living originalism. I don't quite think it's originalism per se, but it makes a lot of sense. Anyway, so my main points, I don't see a conservative revolution, though I do see a conservative movement in the law. I think what we've seen thus far suggests, maybe only mildly, that we're unlikely to see the Smith case being overturned. And I think there's going to be lots of interesting scholarship in the next year on originalism and the free exercise clause. Thank you very much.
Thank you again. I just said it once. I will say it again after unmuting myself. Thank you, Philip, and thank you, Stephanie. I wanted to just swing it back a little bit between the two of you, but maybe first back to Stephanie on the issue of stare decisis. Both of you have talked about original meaning or the historical experience, but Professor Munoz has suggested, maybe more as a matter of prediction, the normative argument that the Supreme Court may not have 5 votes to overturn Smith, but as a normative matter, should it matter that we have had 30 years of employment division versus Smith, or should the court be willing at this point to discard that rule and bring back the earlier doctrine, which itself had stood for almost 30 years? So I guess I'll go to Stephanie first on the issue of stare decisis. Should it matter as a normative issue, and then maybe you can respond as well as to what you would predict in terms of, especially Chief Justice Roberts, if you wish.
Yeah, and I think Professor Munoz makes a lot of great arguments. I'm an admirer of his work. He was actually just cited twice, I believe, Professor Munoz, by the Supreme Court. So they're an admirer of his work as well. And I think that he raises some really good points. Let me respond to the stare decisis question that you raised, which is an important one. I think some of the factors that the court often considers is whether or not a decision it has is itself a departure from prior law. As you pointed out, Smith was overruling decades of precedent. Sherbert was 3 decades before Smith, but even before that, we had a case in the 1940s called Murdoch, which offered a religious exemption from generally applicable no canvassing sorts of laws. So if you want to go back to when the court really started providing heightened protections for First Amendment rights, both in West Virginia versus Barnett and Murdoch, we had 50 years of that sort of jurisprudence, and now we've had 30 years under the Smith jurisprudence. So I don't think timeline alone is going to answer the question. The court will look at other things like original meaning, which Professor Munoz talked about. I'll get back to that in a second. The court will look at workability. Has Smith proved to be workable? I think the answer to that question is no. Justice Scalia referenced the idea that generally applicable laws should receive deference in his Smith decision without really telling us what a generally applicable law looks like. And it turns out that the courts are all across the map on what it means for a law to be neutral and generally applicable. And as an administrability matter, a lot of the arguments and the evidence that you need to look at, I think, to decide that question is that if done right, if done well, exactly the type of analysis we look at often under strict scrutiny and less restrictive means. Another question that the court will look at is there a reliance interest in Smith? And so for that, I mean, Smith itself relied on the premise that sometimes government would accidentally burden religious beliefs, sort of without meaning to, without targeting them, which suggests that they can't be relying on the idea that they will get to burden religious beliefs, because Smith's premise is that that can't be a valid government goal. So I think it's hard to argue that we have reliance interest in allowing government to burden religious exercise. And so, and also, as far as Professor Munoz's point about the fact that maybe we just don't have the votes there with the chief, I think that's a very fair question to raise. What we might see, let's assume that that's right. I think there's an interesting question there, but let's assume that Professor Munoz is right. If that's true, what we might see the chief doing is pointing out that Smith actually was never meant to be the be-all and end-all where the sun of free exercise clause rose and set on Smith. I think Smith has been interpreted to cover far more than it should. And that is one reason, for example, that Professor Hamburger, who Professor Munoz mentioned, actually filed an amicus brief against the government in this Fulton case, where the Supreme Court is deciding whether or not to overturn Smith. Because in Fulton, we have a government dealing with a policy that has changed multiple times, that it changes every year, that it basically minted for this Catholic adoption agency. And at that point, a lot of the premises on which Smith relied about a democratic process with the legislature don't apply, about the government just incidentally burdening religion as opposed to being aware of religion and having the opportunity to accommodate, that doesn't apply either. And so there are a lot of ways in which I think Smith, even interpreted correctly, even if it stayed on the books, should be interpreted much more narrowly than it has been. And that's, I think, a persuasive argument Professor Hamburger makes in that case. So I think I'll just pause there because I think some of the originalist arguments are worth talking about later, but those are some of the things that I think will be weighing on the court's mind when it takes up the Fulton case.
Thank you. The one sort of factoid or two factoids that may be worth noting just on the prediction issue are, number one, you did have 4 justices last term in the Kennedy case in a opinion by, I think, Alito respecting denial of cert, 4 justices, not including Chief Justice Roberts, suggesting that they were open to reconsidering Smith. And then you do have these coronavirus order cases, especially Chief Justice Roberts' opinion supporting the California order and you could say, well, the issue of Smith isn't presented, but if Smith were not controlling, presumably you might have an additional layer of analysis that he did not provide. In any case, I do think there's at least some, it's certainly not definitive, but there may be something to Professor Munoz's point that maybe the chief won't be ready to go there. On the other hand, and I'd be interested to hear from Professor Munoz on this point as well. Doesn't the complexity, arguably the veritable maze of free exercise doctrine, and I say free exercise as opposed to free exercise First Amendment doctrine, because you have RFRA, you have state constitutional law, you have state RFRAs, you have the ministerial exception. All of that, I mean, wouldn't the law be more coherent, at least at the broad general level, if we went back to the pre-Smith approach? So I guess I'll throw it to Philip on that.
Yeah, no, I think you're exactly right. Ironically, let me answer the question. Let me just say you're right to that question. I think you're exactly right. And let me answer the question that you posed to Professor Barclay simply by saying, I don't think stare decisis will hold much sway in keeping Smith because, as you yourself nicely documented in your introduction, there's so many ways to get around Smith. It's a long-standing precedent that's long been avoided in all sorts of ways, and therefore that lessens maybe the weight of stare decisis, but at the same time it also lessens the need to overturn it. I mean, I don't want to sound too crass here, but when you want to avoid it, you can figure out a way to avoid it, basically. So why overturn it? Justice Roberts can. This is going to sound too political, and I don't mean it, but it fits his style to say, look, we can reach the result here without making these major changes in the law, even if a practical effect might be to make the law more incoherent. It appears more conservative in a Burkean sense of meandering on. I don't like that. I'm much more a partisan of clarity one way or the other. And I should say, my speculations on whether Smith will be overturned or not are just wild speculations. I mean, who knows?
Right.
I'm just reflecting on what I see from this term, and it would have been very. Let me just say one more thing, maybe to clarify my remarks. It would have been the votes were there to make a significant change in Establishment Clause law. I mean, I should have been more clear about this. If Justice Roberts wanted to overturn Everson, Lemon, all the strict separationist precedents, he's the vote to do it. And they could have done it, and they had a nice case to do it in. He doesn't seem to want to do it.
Just with respect to whether Smith will in fact be overturned, the other point to note, I personally would not regard it as impossible to imagine Justice Breyer or Justice Kagan joining an opinion that would bring back the pre-Smith doctrine, given some of their votes in other religion-related cases, including their joining of what I would regard as a very broad ministerial exemption decision in Our Lady of Guadalupe. So who knows? I mean, I think your bottom line point is that it's all speculation is accurate. Let me switch gears just slightly, and audience members can be working on their questions because we'll be turning to that within the next 5 or 10 minutes or so. But I'd like to go back to the title of this panel, Balancing Religious Freedoms in a Pluralistic Society, and ask each of you whether or not it is relevant, whether or not it is potentially disturbing that issues of religious freedom, including especially issues of religious exemptions, have increasingly seemingly been connected to quote unquote conservative claims and arguably conservative political positions, basically being used or being advanced to protect traditional religious believers, oftentimes against claims that are alleged to advance things like equality, especially equality for members of the LGBTQ community. You see that, for example, in the Masterpiece case. You see that in the pending Fulton case. And you see that writ large in the dramatic shift of opinion in the political community, including the legal commentary community, which has a political or normative tint to it, obviously, away from broad support for religious exemptions. When RFRA was enacted in 1993, it is often pointed out that the congressional support for the Federal Religious Freedom Restoration Act was virtually unanimous, signed into law with great acclamation by a Democratic president, Bill Clinton. And by the time you fast forward to 2020, it is instead portrayed as a veil for discrimination. Does that play into how we ought to think about religious exemptions, how we ought to formulate constitutional doctrine, how the Supreme Court should decide that case, the issue of doctrine, or are we sort of beyond the point of attempting to redeem religious freedom as a truly neutral fundamental principle to protect the religious liberties of everyone? I guess I'll go with Stephanie and then Philip on that question, if there is a question. Maybe I just made a comment, but if you have any reaction, I'd like to hear it.
I think you're absolutely right, Dan, that this is something that we hear a lot more in the media and as a critique of religious exemption. So it's an argument that I think really merits some attention. There's a study that I would recommend, or an article with some empirical analysis, just surveying what does the universe look like of these religious exemption cases under a statute called the Religious Restoration Act. This was by Luke Goodrich and Rachel Busick, and I think it's called Sex, Drugs, and Eagle Feathers, something like that. But what they found is that by far the most frequent beneficiary of successful religious exemption cases were religious minorities. It might be Muslims in prison or Native American groups or Sikh groups, but by far those were the groups who most often benefited from RFRA. I have an article as well with Professor Michael Instill that's forthcoming in the Harvard Law Review that talks about how important it would be to have this sort of robust protection for indigenous peoples, how they would be a real beneficiary of having a more robust religious exemption framework in place. So I think that you hear the claim that religious exemptions are about conservative causes or political issues or just protecting Christians. Empirically, I don't think that that's true. Those are the cases that become really high profile and controversial, so they take up a lot of the oxygen. But the groups that we would be really hurting if we took away religious exemptions surely include those Christian groups, but they would include, just in terms of volume, more religious minorities. I think that's an important thing to keep in mind.
Well, you have to note that at the Supreme Court level, the cases that have reached the Supreme Court, you do have the Muslim prisoner case, Holt versus Hobbs, in which the Supreme Court unanimously protects a Muslim prisoner's right to wear a short beard under the RLUIPA statute. But you also have Hobby Lobby, you have Masterpiece, you have the ministerial exception cases, at least the most recent one, well, all of them really, raising at least potentially the issue of discrimination against same-sex married couples who are parochial school teachers. I know that's an issue in Indiana, for example. So you do have, but you're right, but the argument that this is really about, well, I guess to put it differently, and I want to get Philip in here, but if the Supreme Court is going to reconsider employment divisions versus Smith as a prudential matter, wouldn't it have been preferable, if there are such cases somewhere out in the pipeline, to take the issue up in a case that does not involve a claim of discrimination against same-sex couples? I mean, it makes it almost impossible to avoid the characterization of the matter as one of politics or equality versus free exercise, rather than the broader question of exemptions. I guess you can jump back in, but let me get Philip in first.
Yeah, I can only sort of affirm everything you've been saying, Professor Conkle. I mean, I think your first point on the real change in the culture, and this might be a little bit unpopular to say, but I see a real change on the left. I mean, religious exemptions was a liberal dogma. Justice Brennan was the author of the Sherbert test, first exemption test. ACLU was the organization that would champion for religious exemptions. Religious exemptions were a liberal cause, and now, at least on the far left, it's religious exemptions are viewed as an evil, and that's within my professional lifetime. It's really quite amazing to see, and I think not healthy. I think it's very bad when religion becomes a partisan issue one way or the other. So I think I don't know what to do about it, candidly, but I think it's unfortunate, and that's why, just to agree with you again, it's unfortunate that that there's going to be such a change in the law that it would happen when it seems like it's one side wins and the other side loses. In general, in our politics, what we need, this judicial, or I guess my personal or political opinion is, we need to figure out a politics that lowers the stakes for everyone. I'm not exactly sure how to do that. I tend to think we ask too much of the law, both on the exemption side and on the non-discrimination side. My own thoughts of a tolerant society, or as we just let people live like they want to live by leaving them alone. That's what I'd like to see more of. That seems to be not our current trend. There's a sort of new moral purity in our politics. I see the exemptions as a response to that demand for purity, moral purity, and also, candidly, a sort of religious identity politics. So I think these are unfortunate developments, and I wish I knew better how to be persuasive on how to lower the stakes of politics for everyone, so we had a more tolerant and pluralistic acceptance of a pluralistic society.
Yeah, Stephanie, do you want to jump in?
Yeah, I agree with what Professor Munoz was saying, and I think that a lot of attention does get put on the idea that, oh, we're seeing a lot more religious exemption cases, but I think Professor Munoz's point is critical, which is that, well, we're seeing an increasing government intrusion into the ability of individuals to exercise their religion. And let's just focus on discrimination for a second, since you raised this question in this context, Dan. So one thing that I think is unfortunate is when we see claims of discrimination that almost equate to a claim that you disagree with me. You won't sort of buy into whatever the prevailing orthodoxy or popular belief is. And that hasn't just started recently. I mean, in the 1995 Hurley case, this was a free speech case, not a religious case. The court noted there that the government was interpreting its public accommodation, anti-discrimination laws really broadly to apply to a lot more things than traditionally it had been in the past, which was part of why we had this conflict. And there the court ruled unanimously for First Amendment rights. In Fulton, I think another example of this comes from the fact that there wasn't actually even a same-sex couple that complained about the adoption agency. The city read about their religious beliefs in a newspaper and said, we can't have that. And that looks a lot more like we just want to be in a society where we punish those who don't toe the popular view on some of these sensitive moral issues. And look, in our country, Americans disagree about sex and religion. Like they have from the beginning, they will continue to do so. And I agree that it's better to have a society where we can live and let live instead of trying to force one preferred view by government and punish those who disagree. And as long as we see government trying to do that, we will see more litigation, but it's not because religious people are changing their beliefs or doing anything different. I think the change is on the other side.
Thank you. Let's, Richard or Eric, do we want to move now? If we have some Q&A, would you like to present what we've got, and we'll take it from there?
Sure. Thank you again, Professors Conkle, Barclay, and sort of really appreciate your time here and contribution. We have a couple of questions in the hopper, and I want to invite anyone in the audience to continue to submit questions. We have about 20 minutes left here on the broadcast. So I think the first question that we're going to go to here is, if Smith is overruled, how, and by then most likely an expansion of the free exercise right, how will that really interact with state level constitutional provisions? And do we see them being mostly overridden or conversely strengthened? Just curious about the interaction with state constitutions.
Well, I'll take a stab at that. I mean, I think the state Blaine amendments took a real blow this term, and overturning Smith would only add to that, perhaps. Maybe I'm talking off the top of my head here, but what you'd see are carve-outs from state non-discrimination law. These wouldn't be state constitutional provisions necessarily, but I guess it could be. But they wouldn't necessarily be Establishment Clause provisions, but Smith being overturned would conceivably offer a lot more protection from new state level, whether at the constitutional or just statutory level, non-discrimination law. So that would seem to me the biggest, having not thought through this issue clearly, not the biggest impact.
I would just add that even without overturning Smith, I mean, Espinoza already indicates rather clearly that the state law Blaine amendments, the sort of church-state driven prohibitions on funding for religious organizations as such are pretty much out the window. I mean, there may be a tiny little window for a state to try to deny funding for religious purposes as such. But without regard to Smith, that decision in Espinoza especially, I think, is pretty broad. And it's really, as Professor Munoz suggested earlier, without overruling anything, the Supreme Court has confined an earlier case, Locke versus Davey, virtually to its facts, in which the Supreme Court in that earlier case suggested states could be stronger in protecting church-state separation than the U.S. First Amendment Establishment Clause required, that there was play in the joints. There's very little play in the joints left, I would suggest, after Espinoza.
Can I ask you just a quick follow-up on this, Professor Conkle and Professor Barclay? Why don't you think they just overturned Locke v. Davey? I mean, the Chief Justice seems to be doing intellectual stuff to uphold this case that no one really cares about, and why not just overturn it?
I would be with you, and I think the explanation, if there is one, may be what you said earlier about the Chief Justice, and maybe there's just a general institutional tendency on the Supreme Court not to overrule if they don't absolutely have to. There are opinions, for example, by Justice Gorsuch saying that distinction doesn't really work. So, maybe one more case, and they'll say Locke v. Davey has been discarded into the dustbin of history. But no, I think you've got an excellent point.
Yeah, I think you see the court take this approach with a lot of its precedent, including in the First Amendment area. I mean, this is what they've done to Lemon. It's still actually not clear that Lemon is overturned, even though it essentially really is dead letter, and lower courts have already seen that. So I think you're right that the Chief prefers an incrementalist, death by 1,000 cuts approach. Whether that's a good thing or not is a separate debate.
And bear in mind that Smith itself purported not to overrule Sherbert v. Werner or Wisconsin versus Yoder, and maybe the Supreme Court can now overrule Smith without saying it's overruling Smith. We'll see what happens. Is there another question, Richard?
Perfect. Yes, perfect mentioning there on the preceding cases. So, just curious, are the precedents before Smith, specifically Turner and Werner, really that different? And we have a question here about how strict scrutiny relates to this.
So, one thought I'll share about that is there was this interest. Basically, the question is, strict scrutiny is sometimes lost even before we had Smith. So, does it really matter that Smith's watered down that standard? I think it does matter. There's a number of cases I could point you to sort of pointed to Smith as the but-for cause of that outcome. So one example is there was a Hmong family that had raised a religious objection to an autopsy being performed on a loved one of theirs who had passed away. And this case was pending when Smith was decided. And so before the Smith ruling, they had won at the district court. And the district court said, that's a burden. There's no good reason for the government to do this. You have a religious exemption. And then Smith came down, and the court on appeal reversed itself and said, well, we can't really offer you protection anymore because that rule has changed. And I think that you could point to a number of different examples like that at lower court levels where Smith changed things on the ground in litigation. I also think something that we don't see in litigation that will not show up on the dockets of case law is that I think government was more careful when the rule was Yoder and Sherbert than it is under Smith. I think government self-filtered out some of the policies that were more likely to create burdens on religious exemption. And so we never had litigation over them. And I think that that's a good thing, and that it's unfortunate that itself has gone away. One reason why, if the court was willing to put more teeth into religious exercise protections, you might see government bodies like the city of Philadelphia being a little bit more cautious before they try and shut down a faith-based adoption agency that hasn't actually done anything to contradict any laws on the books yet. I think that would be a good thing for our society.
That's a really important point that Professor Barclay just made, that you can't measure the effects of overturning Smith or the Smith decision simply by looking at how cases came out. It's all the cases that never make it to the court because the law is different. That's the real impact.
Are there other questions, Richard, or do you or Eric have any questions?
That's about all the questions here in the hopper that related to the topic. I'm curious if there are any other thoughts from the panel.
Yeah, I have one more question that we had talked about by email a little bit before, and I don't know, maybe we've already at least flirted with it, and that is, does the Supreme Court have alternatives as a matter of doctrine that would not bring back Smith, I should say would not bring back pre-Smith doctrine in full form, but that somehow would get away from the rule of Smith in a way that might be more helpful than the general applicability doctrine that is being debated? Or is it really sort of go back to pre-Smith or stick with Smith, complete with all the complications that have followed?
Well, I think they've outlined a couple different paths. You know, the religious animus rationale in Masterpiece Cake Shop, the expansion of the ministerial exception under, originally Trinity Lutheran, and then the recent Our Lady of Guadalupe. So yeah, I think that's one of the reasons why I think actually Smith won't be overturned, because there's other ways that the court has found to interfere with, or if not strike down, what candidly to me seem pretty noxious actions by government. That doesn't mean, that's not really an argument against Smith being overturned. I just think it's sort of in a practical way, because they've developed these alternatives, maybe it actually lessens the chances of Smith being overturned.
One thing that I want to note is that even if Smith was overturned and we had some sort of more heightened scrutiny that applied in more contexts, I think a lot of people sort of have in their head that would become the new rule everywhere if Smith were overturned. But there's a lot of areas already where Smith doesn't apply, and I think whatever the new rule would be if Smith were overturned also shouldn't apply. And the ministerial exception is one example of that, where we don't engage in balancing. It's not heightened scrutiny. It's a categorical bar on government being able to interfere with church leadership. So I think part of what you would want to map out is what are some of those areas that already Smith shouldn't or doesn't apply to, and then what are some of the areas left where maybe there might be some space for a default rule that requires more heightened scrutiny for the judiciary.
I suppose, let me just say something that's probably obvious to anyone who thinks about it, but maybe it shouldn't be, but I think it is. If the Democrats win the presidency, and especially if they win a Congress, I hate to say this, but I think it's simply true. There's a much more highly likely that Smith will be overturned. I just think that's the way Roberts operates. That he will want to mitigate, same way that he's been sort of mitigating some of, depending on your view, Trump's worst policies or some of the effects of Trump. You know, if he sees a Democratic president and a Democratic Congress, I think all sorts of things will be on the table. The withdrawing of tax exemptions for religion, withdrawing of perhaps of RFRA, and I just think you're more likely to see Smith accordingly being overturned.
I think that's a really interesting point. And as you mentioned, I mean, there's pending legislation that's gone nowhere that would create a carve out from RFRA for anti-discrimination claims. You could at least imagine, I don't think this would happen, but RFRA is a federal statute. It could be repealed in its entirety if Congress was so inclined and the president were inclined to sign it. So I think that's an interesting point, just in terms of the the political culture and how the Supreme Court might in fact respond to that. Richard, you're muted.
Yep, thanks. Speaking of RFRA there, Professor Conkle, we have a question from the audience on that. Would finding money damages remedy under RFRA, like in the Tanvir case involving Muslim plaintiffs, help with the political perception problem that was being discussed earlier?
Do you know, or do any of you know, is that the Muslim no-fly case? I mean, is that why it would have that? I mean,
it's the case where some Muslim plaintiffs were being pressured by government to essentially act as informants on their own religious congregations.
Oh, that's right. That's right. Yeah. So do you have a reaction?
I do think that this case poses a really interesting issue for some of the critics of who have been saying religious exemptions just protect Christians and conservative groups, and we should be hesitant of them. Some of those same groups have already come out and said, we know we usually try and protect minorities or Muslim groups, but this case is different. We don't think that they're entitled to protection here. And so I think that highlights a little bit about how some of those arguments about minority groups are more of a rhetorical ploy than actually a principled stance. For me, the principled stance is that we should offer that protection of unnecessary interference with religious exercise, regardless of the religious group. And I think the Tanvir case, if it allows for monetary damages under RFRA, will even provide for more teeth and more of a robust protection for precisely the types of plaintiffs at issue in that case and groups across the board. And I think that would be a positive thing.
The other point that I'm reminded of is that, the lower court in Fulton, among other things, rejected a Pennsylvania RFRA claim that is not part of the U.S. Supreme Court's consideration, in part on the ground that the court concluded that there was, in fact, even if the Pennsylvania RFRA were triggered, there was a compelling justification to enforce the anti-discrimination law. Mm-hmm. That's an issue that the Supreme Court has not directly confronted. One could bring back pre-Smith doctrine and still conclude, consistent with cases like Bob Jones University, that prevention of discrimination requires application even to religious objectors. It could also make nuanced distinctions, as I think maybe it should, between nonprofits on the one hand, commercial entities on the other. But that's potentially in play as well. You could have, Smith does not, as you indicated earlier, Stephanie, at the beginning, I mean, Smith is not a get out of jail free card, pre-Smith, I should say. The government still can attempt to satisfy strict scrutiny, and even to conclude that strict scrutiny is required is not necessarily to say that the government's interest in promoting equality isn't sufficient to trump it.
Yeah, I have some thoughts about that, but Professor Munoz, do you want to go first on that question?
Well, I could say, no, it's a very nice point, and what I was thinking of is Professor Kunkel's earlier remark about, maybe overturning Smith might have been better, or would be better if it was a different type of case. What I could see is a case where they overturn Smith but rule against the religious plaintiff. So, well, there was a compelling interest, but it seems like you overturn Smith in a loss case, that the outcome of which is a loss for the religious litigant. That would take a different type of case, I think. I could see that appealing to. I feel like I'm beating up on the Chief Justice tonight, but I could see that appealing to him. Yeah.
One quick thought I'll just offer is, because this argument is being made, that even if we applied strict scrutiny, the government's interest in preventing discrimination is always a compelling interest and should win. Like, in a way, we should give the government a trump card when it is dealing with protecting, minority groups or disfavored groups under anti-discrimination laws. The problem with that argument is that the Supreme Court has already rejected it 3 times. It rejected it unanimously in the Hurley case I mentioned before from 1995. That was a discrimination law, a public accommodation law that the court said could not be applied to burden speech and association rights in that case. It was rejected in the Boy Scouts v. Dale case, and it was rejected again in the Masterpiece cake shop case. The court there didn't treat anti-discrimination interests as a trump card. I think you have to have a much more nuanced argument than that. In Hurley, the court looked at, does the government have, or does this particular public accommodation or service have some sort of monopoly that is preventing people from being able to get this service elsewhere? Is it a really important service? Is this private entity discriminating based on class, as opposed to just objecting to participating in a specific type of event or message or service? And here, if you look at Fulton, for example, where this is going to come up again, the agency in that case is one of like 30 in the city. So it by no means has monopoly power on same-sex couples becoming parents in Philadelphia, which is probably precisely why same-sex couples never actually asked them to certify them for adoption and foster care. And the city, or excuse me, the Catholic agency doesn't actually object to serving LGBTQ members based on status. They're just saying, we just can't write this report evaluating certain types of marriages or relationships. Those include unmarried ones. They also include same-sex ones. And so if we're following the reasoning of Hurley, that seems like a case to me where even under strict scrutiny, the government doesn't have a strong case why closing down this agency is really going to provide the sorts of access opportunities that those laws are geared at providing.
Professor Barclay, there's something else that supports your very good point, which is, just the court itself in Our Lady of Guadalupe, right? They made the argument in expanding the ministerial exception, right, in light of a non-discrimination claim. So it just does mean that, in addition to the reasons you say, that the court is likely to buy that argument, like at least not this court.
That's true, and Hosanna Tabor was also dealing with an anti-discrimination law. So those laws are important, they are worthwhile, they are not trump cards when we're dealing with conflicts in the First Amendment space.
I think that I'm not sure I would read Masterpiece the way you do, Professor Barclay, in terms of discounting the anti-discrimination interest, since it's based on this finding of animus. But other than that, if you look at the previous cases like Hurley, I think one nuance that could be drawn would be to distinguish between the commercial marketplace on the one hand and nonprofit groups on the other, which might protect the Catholic group in Fulton, but might not protect the Christian or other objecting baker in a commercial marketplace setting. That would be a nuance that could be drawn, whether or not it should be drawn. And we're really getting, just as our time is running out, into the real issue, which is at one level, to what extent is the equality interest, is it sufficient to trump if it doesn't entail tangible consequences of any significance, but instead is based on a dignitary claim or a claim of dignitary harm, as against the claim of religious liberty, which also includes a dignitary element, among other obvious interests that are at stake. So it really is I think, a significant and difficult issue to grapple with in terms of the interests on both sides. So with that, Richard, are we at the end of this session?
I believe we are. And just want to thank everyone here on the panel, Professors Conkle, Barclay, and Munoz. This was a wonderful discussion. And I think we're all waiting with bated breath to see what the Supreme Court's going to do this next year. Just as a note of organization, if you were able to submit your ARDC number with registration, great. If not, feel free to follow up with the Eventbrite link, and that will get it back into our paperwork. It has to be submitted has to be included with the paperwork when we submit to the bar. Other than that, I want to thank my colleague Eric Wesson and our panelists one last time, and thank you all for attending. Have a wonderful evening, everyone.
Thank you.
Thank you.
Thank you.
Thank you.